Hello, hello, hello. Good morning, everyone.
Hello.
Pardon my delay. I had gotten a prior link for Google and I was joining or attempting to join by Google. That was my fault. I apologize. Good morning, everyone. I will try to launch into a discussion of fair housing, and I welcome any and all questions that people have. I just want to indicate to you that I'll run through several documents today, and in all likelihood, we'll probably get to most of your questions, and I'm sure some of you have some specific ones. But with that said, I'll just jump right in and get started. Let me see if I'm capable of sharing a screen. And I'm going to start that screen share now. Can you all see a document I've highlighted with some yellow writing on it? Okay, good.
Yeah.
All right. So let's, now I've switched documents. I'm looking at the fair housing form, and I'll just start with a little bit. First, I thought it would be helpful if I told you all just a little story recently, just to impress upon you how important some of these laws, rules, and regulations are. It wasn't involving a licensed real estate agent, but it easily could have been a licensed real estate agent. And this person was working as a part-time property manager for a specific property. She was a part-time manager. And anyone out there, if you could just make sure you're muted so we don't hear background noise, just try to do that if you can. And so this property manager was fielding rental applications, and one of the rental applicants indicated that they had dogs, and small dogs or something like that. And the owner was okay with that. But after they got approval and they signed the lease and they furnished their initial deposit, they revealed to this property manager person that the pets weren't dogs, they were pot-bellied pigs. And the tenants further said that these pot-bellied pigs were emotional support animals or service animals. And the property manager reported this to the owner, and the owner was kind of old school. And the owner said, I don't care what kind of animals they are, I'm not having pigs in my rental units. And the property manager told the owner, well, you know, they're pot-bellied pigs, they're small, and for whatever it's worth, owner, I'm advising you that you should accept them as tenants because I don't think it's appropriate to discriminate against them based on the fact that they have emotional support pot-bellied pigs. And the owner said, I don't care, I'm not having pigs. Well, you all know where this went. Approximately 90 to 120 days later, this property manager called me up in tears because a complaint had been filed with the Department of Fair Employment and Housing, and both the owner and this property manager, this part-time property manager, were being hauled into the Department of Fair Employment and Housing, and they were being made to answer a complaint of discrimination by these tenants. And I met with the property manager and we formulated all our defenses. And one of our defenses was we told the owner to accept them and the owner refused. Well, you can imagine what the owner was saying. The owner was saying, no, 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 it was the property manager who did this. And this property manager wasn't being paid very much. They were doing a lot of work. They were part-time. This wasn't even their job. It was just a side job. And the owner tried to blame it all on the property manager. And in the middle of this fair employment housing hearing, process, the officer who was presiding over the fair employment housing matter called up the property manager and said, well, the tenants are willing to settle this matter. And the tenants' demand to settle the fair housing complaint was $30,000. That was their demand, to settle the fair housing complaint. And of course, the property manager was in tears. And I said, well, that sounds like an easy question to answer because you can't pay that. And she said, yeah, I can't. And I said, well, if you want to offer a few $100 just as a nominal way to resolve this, go ahead, but you can't write a check for 30,000. Plus your defense is, one of your defenses is, it was the owner who made this decision, not you. Okay. Now that process turned out okay. The property manager got out of it unscathed, but for a good 6 months, she lost a lot of sleep. She was in a bad way emotionally, and she had this hanging over her head the whole time. And any one of us as real estate agents could have easily been in that transaction. Even if we weren't a property manager, we still could have been the listing agent for the owner. And we could have been in the exact same position, even though we weren't property manager. We were still the agent of the owner with respect to these tenants. So that's a good little story overview for everyone to try to keep in mind, that you should keep these rules in mind. And my theory is, as long as you are keeping these rules in mind, the likelihood that you're ever going to violate them, to say nothing of the likelihood that you're ever going to be hauled into the Department of Fair Employment and Housing and threatened with a $30,000 claim, I believe that by keeping these rules in mind, you will minimize that potential. And that's basically all we can do in these situations. So a few years ago, actually, I don't know how long this form has been available through CAR, but there is a fair housing and discriminatory advisory. It's CAR form FHDA, and the most recent revised one is June, just this month. So it's a very fresh form. And what it will tell you is the reason that California values fair housing, and the reason that these rules exist largely in California, is because California views the right of employment and the right of housing to be sort of similarly important rights that are important for the state to protect all individuals. So the state wants to protect all individuals' right to have a job and be free of discrimination and harassment. And it also wants to protect all individuals' rights to obtain housing free of discrimination in housing. So the vehicle by which California imposes these rules is called the California Fair Employment and Housing Act. And you can see it referenced right here. So California, what we lawyers affectionately call FEHA, F-E-H-A. And so California deals with employment and housing in the same, almost the same breath, and it applies virtually the same set of restrictions. But the source of these laws and rules and regulations is greater than just that California Act. The federal government provides fair housing protection, and that's known as FHA, also known as Title 8 of the Civil Rights Act. And all these things do the same thing, or they try to do the same thing. They try to prohibit discrimination and harassment in this context, in the case of obtaining housing. And you can see this mission statement here in the Fair Housing Forum. All housing in California is available to all purposes, to all persons, and discrimination, as noted below, is prohibited. It identifies resources that are available for people who feel they've been victimized, and they can contact, among other things, the Department of Fair Employment and Housing. And again, we can have one of those hearing complaints. There's also something in California called the Unruh Civil Rights Act, which prohibits taking away anyone's constitutional rights and protections. The Federal Americans with Disabilities Act, that's the ADA. And there are many other fair housing laws that exist in California. So this is a well-established body of law. It's heavily regulated by statutes, and the statutes sort of lay it all out. And these statutes tend to be very broadly worded. And what you see in these statutes, and the CAR form attempts to summarize it here, is that these statutes create what are called protective classes or protective characteristics. And basically, every human being falls into one of these protected classes. And what do we mean by protected? We mean that if discrimination or harassment is based, and in housing, we're primarily talking about discrimination, but in this body of law, harassment and discrimination can be used interchangeably. But what we're saying is, in this area of the law, with respect to housing, you can't discriminate against someone based on their membership in any of these protected characteristics. So you can't discriminate against someone based on race, based on their age, based on the color of their skin, based on their national origin, based on their gender, their gender identity, their gender expression. The laws prohibit owners from discriminating against these people, and these discriminating against people based on their memberships in these kinds of protected classifications. And everyone at some point falls into a protected classification. The only question is, are you being discriminated against because you are a man or a woman, or because of your gender identity or expression, or because of your sexual orientation? These things are very, very broad. And what do we got here? 1, 2, 3, 4, 5, 1, 2. So 20 some odd characteristics. Okay, let's take a look at briefly the statute itself. This is the California Fair Employment Housing Act statute as it applies to housing. There's another measure that's almost parallel to it that applies to employment, but again, this is called Fair Employment and Housing, and that's the overall act, and here we're under housing discrimination. And obviously, the statute prevents, it lays out at the very beginning the same characteristics that we've talked about. For any owner of housing accommodation to discriminate against or harass any person because of their all these 20 some odd characteristics, and every human being falls into one of these characteristics. It's only a question of whether they're being discriminated against because of this particular issue. Just 1 second here. I have to tell somebody I'll call them back. Otherwise, they'll have an emergency breakdown. Okay. Now, obviously, the owner is not supposed to discriminate, but this statutory scheme clearly reaches to us as real estate agents. It expressly reaches to us as real estate agents. It talks about how owners can't discriminate, but it also says it applies to any person who makes, prints, or publishes, or caused to be made, printed, or published any notice, statement, or advertisement with respect to sale or rental of housing that discriminates. It applies to any person who discriminates against anyone based on these character traits. And so we can easily be lumped into the category of people who discriminate because we may be representing an owner who's discriminating, and we have to be mindful of that. We'll talk about how we address that later. It says it applies to any person who aids, abets, incites, compels, or coerces doing any of these things. Well, we could easily be accused of aiding and abetting every time we try to help an owner discriminate in this matter. For any person for profit to engage in any of these practices, and that clearly applies to us. And then it specifically says, for any person or other organization or entity whose business involves real estate related transactions to discriminate against people based on their protected status or one of these classifications. And the form itself also notes that that the National Association of Realtors has passed articles that specifically apply to this. So the National Association of Realtors Code of Ethics, Article 10, also says that real estate agents are not supposed to discriminate on the basis of any of these protected classifications. And apparently, as part of this, the California Business and Professions Code has required that we have some education on this subject, and that's partly what we're doing now. And the DRE also can punish this if it happens. So obviously, we all know we have a strong incentive not to engage in this behavior. It doesn't just apply to our owners, it also applies to us as well as real estate agents. Now, you should know that your California Association of Realtors has a form, or it has a specific file folder, and you should all find this inside your California Association of Realtors, legal documents and educational documents. And it's a fair housing folder, and it has a number of publications and bulletins and memos that talk about specific things. There's a section on why these buyer interest or buyer love letters were sort of disapproved and have now been sort of phased out. There's a subject on landlord-tenant law, pets and assistance and service animals. There's a bulletin about Section 8 and income discrimination. There's a summary of the fair housing laws, which is very extensive. And there's also a note about how the Code of Ethics of the National Association of Realtors now prohibits what is described as hate speech by realtors. And the reach of this is the Code of Ethics says real estate agents should not engage in hate speech in any context, even if it's just expressing your opinion on social media. Now, the Code of Ethics is also saying we're not, they're saying they may not be able to punish you for that, but they might be able to punish you for that. And they're telling you that as a general rule, as far as the conduct of the real estate industry, is the National Association of Realtors is saying that real estate agents should not be engaging in hate speech, even if they're just expressing themselves in a public forum. So those are developments in the law and in the industry and things we have to be made aware of. One of the things that has been published is a list of questions and answers. And one of these things was interesting in that it talked about, are there specific advertising words that realtors should be aware of that may violate advertising provisions in the Federal Fair Housing Act, but that would also apply to the California laws and regulations. And interestingly, this was promulgated in 1995 by a letter from the Federal Department of Housing and Urban Development. And they talked about how the following rules are generally permissible as forms of advertisement. And, this is HUD's articulation of these rules in 1995. These may have evolved somewhat, but they talked about examples of common words that can be used without violating the federal fair housing laws. Family room, mother-in-law suite, bachelor apartment, master bedroom, 2-bedroom, great view, 4th floor walk-up, walk-in closet, walk to bus stop, jogging trails, wheelchair ramp, quiet street, cozy, rare find, desirable neighborhood, apartment complex with chapel, kosher meals, no bicycle, non-smoking, sober, conduct required of resident. So according to the Federal Department of Housing and Urban Development, these advertising phrases can be considered acceptable. But examples of things that were not considered acceptable, and these may be obvious: white family home, non-Irish, no Jews, Christian homes, no wheelchairs. These are the kinds of things which obviously would trigger potential concerns regarding fair employment in housing. And I will say again that the body of law in this area is very wide. It's very extensive. It's very subtle and nuanced and detailed. And it would be impossible for any of you to know all of this law backward and forward. It's impossible for me to know all of this law backward and forward. But the key, in my opinion, to addressing all these types of situations is being aware of the fact that these rules exist and being mindful of
west on Sunset Boulevard toward North Fairfax Avenue, then turn left onto North Fairfax Avenue.
If anybody could mute their GPS directions, that would be great. If you have a question, just let me know. Thank you. Let me see if anyone said something in the chat box. So owners cannot refuse Section 8 tenants. As a general rule, it would be discrimination to refuse Section 8 tenants. And so, you know, owners ultimately decide who they're going to rent to and who they're not going to rent to. And I don't believe that refusing Section 8 tenants is generally a problem, except in areas where Section 8 tenants frequently rent from, which I consider to be largely in the downtown Los Angeles area. But as a general rule, Section 8 tenants or source of income is a protected status, and it's not suitable to discriminate against tenants based on their ability to pay. And if you want to read more about that, there's a Section 8 and income discrimination memo which has been put out, and let's see if I can find it here. I think I pulled it up. Yeah, I guess I didn't pull that one up. But there is an extensive discussion of Section 8 and fair housing discrimination as it relates to Section 8 tenants. And I would encourage everyone who has more specific questions to delve into that. One of the other questions that we get a lot in this area has to do with service animals. And CAR has put out a pretty good comprehensive guide about service animals. And I'll just walk through that briefly. Federal and fair housing laws require equal treatment of many protected classes. We've talked about that. And that includes persons with disability. And that means being allowed, people with disabilities are allowed to reside with their service animal or support animal. And there's a distinction between the two, but for the most part, as real estate agents, I'm not convinced that we should spend too much time focusing on those distinctions. And what does the law define as any service animal? Basically, any kind of animal. And I offered the example at the very beginning of pot-bellied pigs. All of these animals, I basically believe that all pets are emotional assistance or emotional support animals, whether they're medically qualified as such or not. I think it's hard to argue that pets are not emotional support animals at some level. Now, this area of the law does distinguish between a service animal and a support animal. A service animal has been specifically trained to assist a person with disability with their disability-related tasks. And the classic example of that is a seeing eye dog. So it's a specific animal that's been highly trained, in this instance, to help a blind person move about. Service animals, in a case of a service animal, the disabled person has a right to be accompanied by their service animal, and it is part of their constitutional protections. So if we're dealing with a service animal, then there is no requirement for what the law calls reasonable accommodation. What reasonable accommodation means is that the landlord can make a reasonable attempt to accommodate the request, but that does not apply with a service animal, because with a service animal, the landlord has to accommodate the request. And the general test is, does the person have a disability? The example that I've offered is a visual impairment, blindness. And what disability-related tasks has the animal been trained to perform? Now, as a real estate agent, it's not your job to vet, in my opinion, these issues. I believe that when you're presented with a statement or assertion that this is a service animal or this is a support animal, your job is then to convey to, in this instance, your owner or landlord, they say it's a service or support animal, and really, you don't have much ability to disagree with that. And that's really not your job to disagree with that. I would err on the side of protecting these people's rights rather than figuring out a way around them. And if we get into a situation where an owner is steadfastly refusing, that's something that I think you can talk to me about, and we can navigate how to go through those issues. But as a general rule, you don't want to be party to that as much as you possibly can, because not only may you be engaging in the discriminatory behavior, but as I said before, the first person this owner is going to turn on is most likely you as a listing agent or an owner's agent. And we've been talking about landlord-tenant situations, but the same situation applies in sales. So if an owner is selling a property, and if the owner is making questions or comments to you, well, I prefer not to sell to this type of person, or the people in this neighborhood don't want that type of person, I believe that your job is to sort of shut down that line of communication with you as much as possible. And one of the ways I would do it is, well, oh, look, owner, it's your home. It's completely up to you which offer you accept, but I need to let you know that as a real estate agent and a broker, I'm obligated to comply with laws regarding discrimination and harassment. I can't engage in any type of discrimination or harassment, and I can't encourage or assist you in engaging in any kind of discrimination or harassment. So if the owner says, ask these people to send me a picture of them, that would trigger a lot of red flags. And I would push back on that. And I'd say, no, I can't really do that. Ask these people about their demographics. Ask these people other pointed questions. So you really want to avoid going down any avenue like that. And it starts with your private conversations with your owner. You don't have to turn on them and read them the riot act and lecture them about something, but you can, at least on the first instance, politely remind them that you can't go down that road. Some people have told me that they have applied for a tenant rental, and they've applied for it in these large rental communities, 50, 100, 150 units, and they'll ask the on-site listing agent, oh, well, what kind of people live here? What's the demographics? And they may have an innocent mindset. I just want to know if it's a lot of college kids because of noise. I want to know if it's a lot of working professionals because those people may be quieter. And those types of landlord representatives in those situations, they will always push back, and they'll say, I understand your need for that, but I can't answer any kind of questions about that. We're committed to complying with the laws regarding fair housing and regulations, etc. Just give me 1 second. I want to look for a document here. Just wanted to pull up the Section 8 document that I had found. Okay, does anybody else have any questions right now? At this point, I'll just keep on trucking, so to speak, but I thought it might be good to try to answer some questions that people might have, if anything. Yeah, someone says, my understanding is for a service animal, they have to have certification for the animal. And let me just take a look at the fair housing summary for that. I think there are lots of myths about what is required for this. And I would encourage all of you to refrain from going too deeply down the path of requiring documentation or thinking that it's your job to vet or police these issues. Are they lying? Are they telling the truth? I think that's a dangerous place to be. And I don't think that's really your job. If people have specific situations that come to mind, I would welcome an opportunity to talk with them. Now, again, a service animal is, does the person have a disability, and what disability-related task has the animal been trained to perform? So if a person says, I have a visual impairment and my dog is trained as a seeing eye dog, to me, that ends the inquiry as far as a real estate agent is concerned. I'm not sure I'm asking for medical documentation to verify that. What is a support animal? A support animal does not have to be trained to assist with any disability-related task. A support animal may also be known as an emotional support animal, therapy or comfort dog. Support animals are subject to reasonable accommodation requests. So there isn't, as far as real estate agents are concerned, a requirement of certification. And I don't think it's difficult for people to provide something to that effect at any time. If you ever drive around and you see people parking in disabled parking spots, I can't tell you how many times I've seen people park in those spots and they jump out of their car and I don't know, they look like they could do jumping jacks. And that's because some physician, in my opinion, wrote them something that said, yeah, you've got this, that, here's your entitlement to a placard to park there. And I think almost any doctor with a patient will write a letter that says, yeah, you need this dog to help with your emotional support. And so I don't think that type of certification or letter is required. And if it is, it's very easy to get, in my opinion. And so if we're going down the road of trying to vet or determine if these people have documentation to support their claims that these are service animals or support animals, in my opinion, we're only making it worse. We're only making it worse. Okay. Here are some specific questions. May a landlord charge more in rent or a larger security deposit for the assistance animal? No. So if a landlord charges a standard pet deposit, they can't change that just because it's an emotional support animal. They can't say, well, because it's an emotional support animal, I'm increasing your security deposit to whatever. That would be prima facie discrimination against somebody based on their protected status, because there's no reason why you would charge more for one animal or another. Okay, let's take a look here. Someone says, I have a friend who wanted a service animal and he needed the animal to be certified. Well, that may be true. It may not be. I mean, that I take it as true that someone said, I need this certification. But my reading of it from the real estate perspective is that's not required for purposes of us being found liable for violating fair employment and housing laws. I think it's sufficient for the person to say, I have a particular disability and this animal assists me with that disability, or in the alternative, this is an emotional support dog. And I view that as sort of the end of the inquiry. And I don't favor delving too deeply into that, because I think, particularly in a case with an emotional support animal, that's very easy to get some sort of documentation for that. And I don't want us to be in the position where we're harassing someone based on the fact that they have an emotional support animal. We're only further increasing our risk exposure. And at the end of the day, I don't think we're going to be able, if it comes down to a Department of Fair Employment and Housing hearing, I don't think it's going to be defensible, because I think that's going to be very easy for them to get some documentation. And Carr agrees with me. It says, is an online certificate or vest acceptable documentation to establish the need for a support animal? And they say no. So those things in and of themselves don't establish that the pet is an emotional support animal or a service animal. And I think that that's an inquiry that if we go down that road, we're just getting into more trouble. Pets and support animals are different classes. Technically they are, but I think that it would be very easy for someone to argue that a pet is an emotional support animal. That's my opinion. Okay. Someone asked, that means you can't advertise no pets. I think an owner can advertise and say no pets, but if an owner is confronted with someone who says, I have an emotional support or service animal, then the owner could be in a difficult situation if the owner can provide a reasonable accommodation and refuses to do so, or in the case of a service animal, when the owner has no choice but to accept. They cannot deny, based on the fact that this person has a disability and they have a service animal that is necessary to have them deal with that disability. Now, as far as support animals are concerned, I do believe the law is that the owner can have a no pets policy, and that could be a blanket no pet policy across the board. But I just remind you that if a tenant says it's a support animal, and if a tenant feels that they're being discriminated against because it's a support, because they can't have a support animal, then the landlord, the owner, and the agent can be drawn into a DFEH hearing and asked to explain why they didn't allow an emotional support dog. So or emotional support pet or animal. So I just don't think it's a good area for us to be in, where we are trying to protect an owner from renting to somebody solely because they have an emotional support animal or a pet. That's just not a good place for us to be in. And I can assure you, if the owner gets tagged, he's going to blame you as the agent. They'll do it every time. They'll do it every time. And so it doesn't do you any good to fight and defend for your owner when you know full well if anything goes south, that owner is going to blame you. And they do. They do it all the time. Okay. If anyone wants to verbalize or articulate a question, I'm happy to try to answer it. We've got about 5 or 10 minutes left. Let's run through some.
Peter,
yes.
I was going to say that I just looked it up. It's not mandatory to have a sticker or a vest for a service animal. But
yeah,
if you want to be completely legal, you have to apply for the tag and the vest, and you have to be able to prove that that particular animal has had a certain amount of training for that disability.
Well, for what purpose? I mean, you've described a requirement. What does that requirement apply to?
It applies to service animals only.
No, but that's not what I meant. It applies to service animals in what context? In other words, if we're dealing with housing and someone says, this is my service animal, they're also going to say that it's an emotional support animal. They're probably going to say both. And you're correct that, and as Carr points out, even if they had a vest or some certification, that wouldn't establish that they are a service animal. And I don't believe it rules out that they are a service animal.
No, the vest I'm talking about, there's a specific vest for service animals. A friend of mine had to go do the whole thing for his disability.
Okay, so he wanted to have a certification for his disability. And I guess my point is
to get his dog to be a service animal.
Right, but
he had to have his dog certified, and then that's the only way you can get the tag.
Right. And my point is this: if that same person showed up to rent a house that we were listing for someone, and he said, this is my service animal, I have a disability, and it helps me with a disability related task, I don't believe that the lack of that certification at that time would be suitable grounds to discriminate against him.
It's not what I'm saying.
Okay, I know. That's right.
I understand completely what you're saying.
Yeah, and I understand what you're saying too, is it in order, he wanted or needed a certification requirement. I still don't know for what purpose.
Well, it's a type of disability that he has. It's a physical disability. He's got heart problems. He's got all sorts of things.
Sure. And so
that
he
dog
may have had other reasons for that. For example, he may want that certification if he wanted to fly, if he wanted to take an airplane, and he wanted to say, look, this isn't quote unquote just an emotional support animal. I need this dog with me or pet with me on the plane because of XYZ. Or he may need that for an employment setting. And so I agree with what you're saying, and I think we're just saying the same thing from two different perspectives.
Yeah, something.
We're
saying something similar. The thing that I'm saying is, if people look at you differently if you have that vest on, they actually accept that dog is a service dog, because the vest goes along with a certain, what is it? It's a way of controlling the dog.
Yeah.
But people will accept it more if they see that particular vest, because it's a registered dog is what it is. But
okay.
people that don't see that are a little skeptical.
Fair enough.
That's the only thing I'm saying.
Yeah, I would agree that the existence of those kinds of things makes it more apparent, and people accept it more readily.
Right. And your thoughts about support dogs? Anybody can get a support dog.
I believe that personally, I believe every pet is a support animal.
Well,
that's my personal opinion. And
yes,
an owner does not have to abide by that, but I believe it would be I think it's true. And I also think it's very easy for someone to say it's a support animal, but that's just my opinion. So
landlords are not allowed to ask for the prescription that the doctor gives you? For the support animal?
I definitely, if you're talking about an emotional support animal and you say, if that's an emotional support animal, I want to see the medical prescriptions that your doctor is giving you for antidepressants. I mean, I would definitely not go down that path.
No. I'm talking about, because I know a couple of landlords I know request a note from the doctor saying that animal is their support animal. They don't ask for why or medication. What medication are you on? But they want to make sure that they're just not bringing any dog into the building just because they call it an emotional support dog.
Fair enough. And what does Carr say about that? Support animals are subject to reasonable accommodation requests. So an owner could say, I have a general policy about this. You've said it's a support animal. So I'm trying to see if I can make a reasonable accommodation for you. So please provide me with some sort of doctor's note that says this is an emotional support animal. That sounds fair. That sounds reasonable. The problem is, if the tenant refuses and says, no, it is an emotional support animal, I'm not going to go run to my doctor. My doctor's already told me that. And then if the owner says, well, that's no good for me, so goodbye. Later on, if that tenant comes back and asserts a claim, the defense is, well, we asked them for the doctor's note and they didn't provide it. And then you're in a situation where you're arguing that the failure to provide that note was sufficient grounds to deny them the rental accommodations. And by the time you end up at a DFEH hearing, the person very likely does have a note. And I know people want to say who wins, who loses. But my response is, if you're in front of that proceeding, everybody's already lost. You got an argument. You've got an argument that's a defense. And it's a reasonable defense. It's a reasonable accommodation. And that's what the law of reasonable accommodation is. Now, for instance, with service animals, Carr advises that the housing provider should seek additional verification as part of an interactive process. And they can request whatever verification they want. Do you have a vest? Do you have a certificate? What have you? But in my opinion, what they get or what they don't get isn't likely to change my advice on these particular issues, which is it does us no good as real estate agents to help someone be denied because of a support or service animal. It almost always invites trouble for us. And you can say that to your owner. You can say, look, I'm, there are guidelines here, but at the end of the day, if this is the only reason you don't want to rent to this person, my advice to you is you should rent to them. I'm not a lawyer and I don't want to parse these rules. And if you want to consult with a lawyer, you can, but their request seems reasonable to me. And I don't welcome the opportunity to be in a situation where we're accused of some sort of discrimination or harassment. Now, it's still your property, owner, and I can't make you or not make you rent to anyone. But my advice is, nothing they're asking here seems very unreasonable. I would recommend that you proceed with it. Now, if we end up in a contested Department of Fair Employment and Housing hearing, that's one of the first things I'm going to argue in our defense. Whether we're right or wrong isn't going to matter to me. Ultimately, I'm just going to argue we told them to rent to them, because that's what would be in our best interest. We're almost always losing something if we're arguing in a DFEH proceeding about whether we were right or wrong, this was a support animal or a service animal. And I think support animal is so broad, I don't welcome any fight on that issue, in my personal opinion.
It sounds to me like that landlords can't say no pets anymore.
Well, I don't have it in front of me, but I did read somewhere that landlords can say no pets. That can be their general rule. But if they're met with something that qualifies as an actual service animal, and these are the things we've talked about, certification, etc., they have to accommodate that request. And if they're greeted with an emotional support animal, which is very broad, they're subject to a reasonable accommodation requirement. And then, I don't know if there can be reasonable accommodation or not, but as a real estate agent, under either scenario, I don't think it's in our interest to fight these issues. And maybe it is better for us just to simply say to a landlord, we don't recommend that you advertise no pets. We just don't recommend that because you're limiting your applicant pool. Almost everybody has a pet that probably qualifies as a support animal, and we don't want to deal with reasonable accommodation requirements. So I don't fault you for concluding that, and that may be the better policy, because it may be easier to avoid a lot of disputes in that point that way. All right. Let me see.
Can I add something, Peter?
Absolutely.
Yeah, I feel like sometimes as agents, we get too caught up on the landlord's requirements that they don't want any pets. But ultimately, it's a very long road from someone calling you, do you take pets or emotional support animal? And then for them to apply, get qualified. So I always say, everyone's welcome to apply, but it comes down to the credit and the ability to pay, right?
Well, I would hesitate on telling anybody why they're going to be accepted or not accepted.
No, I wouldn't tell them.
Right. Well, and at the end of the day, I would hesitate on exercising too much control over who the landlord chooses. I think I would offer a landlord my opinions, but I would try as much as possible to let the decision be the landlord's. And I do think what you said earlier is true. I would go into this with a very general, open-minded framework, get whatever applicant you have, forward it on to the landlord, run whatever checks you normally deem. And if the landlord says, I don't know, you pick it, then I think you should exercise an objective, as much as you can, objective, detached reason for picking someone over another that's not based on their protective status.
Right. Like I've had people right away, you know, first text, they send me their certificates that they have an emotional support animal. I never requested them.
Let me just ask about that. I just want to make sure. They send you a certificate that their animal is an emotional support animal, as
Yes.
opposed to a service animal.
Right.
Okay.
One
Well,
of those online things, you know?
okay. Well, great. I mean, so look, I honestly think, I mean, I commend them for opening up with full disclosure, and that's something you have to consider. And I don't know if all other factors are equal, but some people may be more credit worthy and have a better prior history than others. And, you know, you just have to process that information. But we definitely, in that situation, can't be, and we want to minimize the likelihood in that situation that we're saying, no, everything else was the same, but we didn't want you because of your pet.
Hey, Peter,
Right.
I'm confused here because I thought you weren't able to ask for any documentation when it comes to medical purposes, whether
Well,
it's service or support, because I thought you're not supposed to, like, there's a law against that, HIPAA.
well, you're not, the laws overlap and they're a little bit confusing, okay? Now, this is again why I say that it's really not advisable for a real estate agent to be engaging in this inquiry or this scrutiny about whether or not they have documentation to substantiate that's a support animal or a service animal. I just don't think there's anything good for us going down that road, because at some point you will run into problems violating medical privacy. Now, if the owner insists on the tenant, prospective tenant, providing some documentation, I think that it's permissible to say, well, the owner just wants to verify that it's a support animal or a service animal, and could you please provide us with any information you have to support that? And that's about as far as I would go down that road. I wouldn't start asking questions about detailed medical history and are you being prescribed what drugs and whatnot. I would definitely not go down that road. The most I would go down is say the owner has requested certain information or a statement, something, you know, an email explaining why this is your support animal, or something explaining this disability, just so the owner can consider it, because the owner has a general policy against pets. But I wouldn't go deeply down that, and I wouldn't start asking for backup documentation. To me, that just seems like a dangerous road to go down. And you've touched upon one of the reasons not to do it, because I definitely don't think you can ask about medicines and medical information. I do think that in the case of a service animal, you can ask for some additional information to verify, you know, what disability we're talking about and what's the animal trained to do. But other than a very general inquiry, I just wouldn't go down that road very deeply. And you're just a messenger. You're passing on whatever information you have. And when the owner says, what do you think? You say, I don't want to get involved in any of dispute over this. I recommend that, all things being equal, you don't discriminate against them because they say this is a service dog or a service pet or a service or support animal.
Maybe it might be good to say to them in writing, whatever documentation you feel comfortable providing. That way you're stating that if they feel comfortable sharing it, then it's, you know, okay to share it.
Well, that's one way of doing it. You know, there's a tendency to over document things, and sometimes those things come back to bite us. But, you know, I might not have a problem with an owner saying, yes, the owner has received information that this is a service animal. For the owner's records, could you just explain, you know, what this service animal is specifically trained to do, just so I can pass it on to the owner. Something like that. Very mild, very brief. I don't think you should be asking for anything in particular. I think you should ask them for whatever it is that they want to provide if the owner has further questions about it.
If it's a true service dog, my thought would be just ask for the certification. That's all I would really need is the certification saying this dog is a service dog and has been trained in such and such. I don't really want to ask a question to a potential tenant saying, well, gee, why do you have a service dog? That's
fair enough.
That's
fair
a
enough.
little too prying.
But what happens, just to play devil's advocate, what happens if the tenant says, no, I don't want to give you the certification?
But it's not for me. The owner of the building is requesting it.
Right. Okay. And now you've asked for the certification. The owner has requested it. The tenant's not giving it to you. And then you report to the owner that the tenant didn't provide the certification.
Right. Exactly.
And now what happens?
That's off of me. It's on the owner.
Fair enough. We have a defense that we just asked on behalf of the owner, but if we get dragged into a Department of Fair Employment and Housing hearing later on, we'll be named as well. They'll say you asked for a certification.
We're always
that's right.
Everything.
That's right. We're always at risk. And so generally speaking, I'm not convinced that any substantive inquiry is fine. And the only reason I engaged in that inquiry, that mock-up with you, that hypothetical, is just to show you where that goes each step by step. I think it's reasonable to say the owner has asked for some sort of certification or some sort of information regarding the status of this animal. If you can provide it, please provide it. But I wouldn't go much further than that.
And I understand that completely.
I think we're on the same page there.
Yeah.
Yeah, just to clarify, I've never asked for any proof, people voluntarily just texted to me like that. Yeah.
Yeah, as a general rule, I really applaud real estate agents because they really take on the burden of answering questions and figuring things out and going the extra length. It's a natural part of being a real estate agent. You think that that's your job. And real estate agents take on a number of duties and responsibilities that they really don't have to. But I know it's competitive. I know you want to be service providers. And so as a general rule in the industry, you really tend to go to great lengths to find out answers and information. But much of our job simply is reporting information to our respective buyer, seller, landlord, owner, or tenant. And that's kind of it. And if there are specific questions that come up, we can deal with those. But too often we take a duty upon ourselves to investigate, circumvent, get rid of situations. I've seen tenants go and pull permits. I've seen tenants talk to neighbors, all kinds of things. And these things just tend to open up more problems, in my opinion, than are welcome most of the time. All right, I know this is a kind of a tough and confusing topic. There's a lot of information on it, and we're focusing a lot on pets, and that's understandable. I think, but in many respects, some of the bigger issues arise when we're selling property, and there's a concern about whether or not there may be discrimination or harassment against a prospective buyer. And that's an equally fertile area of this law that people need to be mindful of. And so it's just one of a number of things that we always have to be aware of. Anything else? Can't seem to make this go full screen here, so I don't know if anybody has any extra comments. Hold on. Okay. Anybody else? Anything? Just hold on, let me just see something here. Just one second. Is Paula there? Is she still on? Maybe she had to leave. All right, everyone. Look, if anybody has any more specific questions, please feel free to give me a call. And we may schedule a few more discussions about this so we can all have another group talk about some of this stuff as it evolves. There's a lot to be mindful of here, and I'm always happy to talk about it further. Okay? All right. Thank you.
Peter.
Thank you.
Thank you all.
Thank you.
Thank you all very much, and especially grateful for all the questions. I really do appreciate it. Thank you.
Thank you.